Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about viewer questions, typically about divorce and family law. Jesse, co-host, how are you doing, sir?
I'm doing great, Dave. How about yourself?
I'm doing great. Good
Excellent.
to see you as always.
You as well.
We have a lot of incoming emails this time around.
And that's great.
Primarily on divorce, coming off a couple other shows that we did in the past, ongoing questions that people have. So I want to get right into some of these questions, get to some of your answers.
I think we have some bankruptcy questions, too.
We do. We'll get to some of those, too. I want to start with Kevin in Steger. Let me give you a little background here.
Sure.
He's got 2 children. He's got a 6-year-old boy and a 9-year-old girl. The boy is into baseball. The girl likes to draw. He works as a medical tech, earning approximately $60,000 per year. The wife is educated, but refuses to go to work. She may be bipolar. We're not really sure, and possibly psychotic. So she refuses to seek any kind of treatment. So Kevin's in a bad situation here, and he wants to know if he can fight for custody and what is the best interest of the child standard that he's heard so much and read so much about.
Well, we need to talk about a couple things here. First, just kind of generally, all right, it's the law changed, and it's no longer custody and visitation, but by any other, a rose is still a rose. So
Right.
We're going to be calling it custody and visitation for a long time. But what it's called now is the allocation of parental rights and responsibilities, and that's divided into 2 prongs. One is parenting time, or visitation, if you will, and the other one is decision making. And so basically it's broken up into medical decision making, it's broken up into school and extracurricular and religion. And any one of those 4 things can be jointly the parties can be jointly responsible for it, or one can be solely, or somebody else can be solely for something else, or it could be a mix of any of those things. It just depends on the particular circumstances. So with that being said, and I know during our show we're going to be talking about custody and visitation, but it's really the allocation, but custody and visitation is how people kind of know it and they're going to be talking about it. So we have the situation where he's working, and mom's not working, okay? Don't know the extent. He said possibly bipolar. There's a lot of people that have a lot of problems, diagnosed or undiagnosed. And so, and it really doesn't matter the reason that we want to get a divorce in terms of he wants...
Well, he's concerned that the home is not stable for the children while he's out working. So he'd like to come up with a way where he can have the children on a day-to-day basis, and come up with some other kind of provision where the children could be watched when he's at work, either through daycare, through a parent, or a split schedule or something of that nature.
Well, what's going to happen are a couple things. Okay, once he files, and again, we're stepping over a whole bunch of different things here. So
does he even have a shot? Is what he really wants to know, because this would be very costly.
But it's difficult when people say and people ask, "Oh, do I have a shot?" I don't have a crystal ball. I wish I did. And it depends on the county. It depends on the judge. You could have the same.
Is Cook, Steger.
You have the same. You could have the same set of facts in different places, and you could have 2 different judges, and they have a different take on it. So what's probably going to happen, what generally happens by the local rules, and that's true in pretty much any county, is if there's an issue with parenting time or decision-making or custody and visitation, the first thing they're going to do is send the parties to mediation. Now, mediation, there are... non-binding mediation. And so basically you're going to see an attorney who has specialized training. I'm a mediator as well in DuPage. And that person is going to try to guide the parties, to help the parties come to an agreement. That person doesn't have any skin in the game. They don't know any of the people. They're just trying to help them. The mediator's in charge of the process, and the parties are in charge of the outcome. And that's the first thing that's going to happen. Now, there's 3 things that could happen. Mediation could be completely successful and the parties come to an agreement. That's always the goal. That would be nice. But both parties also have to approach it, mediation, like they want to resolve it. And then the second way is it could be no agreement on anything. And so mediation completely failed. Or it could be a partial agreement. That would be the third thing. Okay,
that's probably the most common.
Yeah, they're in agreement on some things, not on the others. But generally the mediator only gets to mediate when it's court appointed, when it's court appointed, it's generally only dealing with issues involving the children, parenting time, and decision making. And so that's the first thing. So if there's no agreement on that, then you rise to the next level, and a guardian ad litem will be appointed. Now, sometimes
that's expensive.
It is. You might be able to pass over the mediation, but it depends. I mean, if there was an emergency situation or something happens where he's trying to not have his wife, and it better be something pretty serious for that to happen, a guardian ad litem will be appointed, and a guardian ad litem again. And
he's worried about psychosis.
Well, but again, he's not a doctor, okay, and he's lived. They've been married for how long, and they've had two kids. Now all of a sudden it's a problem. He married her, okay, and so he's been with her, and he knows. All right, people generally don't change on a dime, okay? It's a gradual process, or it's a traumatic experience or some kind of experience that causes the people to adjust their behavior. So a guardian ad litem, again, is an attorney with specialized training. I'm also guardian ad litem in DuPage, and that person is going to do an investigation. They get appointed by the court, so it's the court's witness, the right arm of the court, and they're going to do an investigation and report back to the judge on what they believe is in the child's best interest. And they're going to talk to the parties, they're going to talk to other people, they're going to get the school records. It just depends. They may do some home visits, although not all the guardian ad litems do. It just depends. And the parties are going to have to pay him. And it sounds
we have
like
a third attorney in the mix.
Well,
here.
a third attorney in the mix. And so it sounds like since the mom
the
isn't
only one
working, and it's going to, unfortunately, there's no other way to kind of do that. And then we get into another level, which is a custody evaluator, 610B evaluator, and there's 610C, which is your own independent witness. And that now you're going into a situation, and that's an actual psychologist, and you're looking at 8 or 10 grand or even more on just that.
Now we're talking bankruptcy.
Well, I mean, unfortunately, that's the way that it goes, and so you really don't know.
All right, so he has a long fight battle procedure ahead of him to even be thinking about having the day-to-day of the children.
Right, but just because somebody has bipolar or somebody has some psychosis doesn't exclude them from exercising parenting time. It is better to have both parents in the mix, and so the court isn't, I mean, there are some situations where, hey, parent gets maybe supervised visitation, but those are extreme.
Okay, very good answer. All right, let's move to Karen in Orland Park. She's in a 16-year marriage with 3 children, 14, 12, and 8, 2 boys and a girl. Kids attend a private school, very involved in their church. No one can believe that the couple is struggling through this marital crisis. Finances are at an issue. The husband earns a modest income, yet attempts to provide the best things in life. The wife chides him that he needs to earn more. So you mentioned a guardian ad litem. This Orland Park case for Karen, the court appointed a guardian ad litem, and she wants to know, why do I need this? Why do I have to have this? And why should I have to pay for it?
I can answer all those questions for you. Why do I need this? Because you and your husband are not in agreement, okay? And because it's not about what's important for the mom or the dad, it's about what's in the best interest of the children. So that's what we're looking at. Because the guardian ad litem was appointed, I can only assume that they've already been through mediation and it failed. And so now the guardian is doing this investigation, because that's the only way the court can determine what's in the best interest of the child.
Yeah, the finances were already an issue.
But finances, and again, look, somebody filed a divorce, and again, custody and visitation, again, we're not, it's allocation, but we're just going to use those terms. I just want to continue to remind our folks at home. And why does she have to pay for it? Because they have an income and they're doing it. And now there's some things in various counties, in Cook County, where they have people, guardian ad litems, that get appointed on a pro bono basis, which means they don't get paid. But there's an awful lot of cases in not just divorce, but family law. And so, if somebody has an ability to pay, then that's going to happen. But also, hey, look, you're trying to get, obviously they're not agreeing on something, and since the parties can't agree, and the judge can't go out there and do all this investigation with all those cases, he's going to rely on the guardian ad litem. Now, this is also important. The guardian ad litem is going to make a recommendation based upon what he or she believes is in the child's best interest.
Is that in
based
the way
upon
of
their
a
investigation.
report, or is it just oral in front of the judge?
Well, it could be. It's really important when the guardian ad litem gets appointed to ask the judge to see what's the scope of it. Is the person going to write a report? Is it just going to be oral? Now, depending upon the situation, because it really does cost more for a guardian ad litem to do a report. If it's going to go to trial, and sometimes what will happen is, the guardian ad litem's report will be oral until it's time for trial, and then the judge will request that the guardian ad litem do a report, because now it's going to trial, now you have something. Guardian ad litem can also be called as a witness and cross-examined, but they don't really actively participate in the litigation.
Is the report hearsay?
Well, but you have the guardian ad litem who's going to be testifying about it.
If they're not there?
If they're not there, what's going to happen is the judge can consider that the guardian ad litem is going to be there. Okay, there's
I'm just
no
wondering,
question
is
about
it an
that.
exception to the hearsay because
Well,
work product,
this
business
is,
product?
This is interesting. It's not an exception in terms of because the guardian ad litem is going to testify, but all the people the guardian ad litem talked to would otherwise be hearsay, but it's going to come in because those are the interviews and the appointments that the guardian ad litem has used to form his or her opinion. And so for that purpose, it's not going to be used for the truth of the matter asserted, but because that's what the guardian ad litem relied on, like, okay, I talked to the children's therapist, okay, unless the therapists are there, it doesn't matter. Well, hey, that gets to come in based upon their opinion that, hey, listen, based upon this and based upon these other things is why I came to my decision.
Well, hopefully they wrap it up relatively quickly because finances are not there, and when they get that first invoice from the guardian ad litem, it might wake the two of them up to the point where they realize they can't get into a long, drawn-out battle. They need to come to a compromise for financial security.
It should, but also the rules say that, hey, the guardian ad litem has also got to file statements with the court so that you keep them going. And here's another interesting thing, talk about bankruptcy. So, Dave, is the guardian ad litem fee, can you bankrupt that?
You cannot.
Right.
So you're stuck with it.
Right. So
and I don't think people realize that when they're first faced with the situation where there's going to be a guardian ad litem and the parties are going to have to either apportion it or one party is going to be responsible for it. In this case, only one party works.
Yeah.
So,
Yep.
Okay, let's move along here to what used to be called visitation, which you now call parenting time. Terry and Joliet has a judgment that's been already entered, but the enforcement of it has gotten difficult. And he wants to know what recourse does he have against his ex. And just to give you a little background here, the divorce is from 4 years ago.
Okay.
Child is now 10, and the judgment calls for alternating weekend visitation, we now call parenting time.
Sure.
It has not been consistent. The husband has struggled with alcohol, and the wife then refuses to allow visitation. Husband accepts his weakness. He's taken corrective action as of late, and he's joined AA, and he wants to get back to the same schedule that was written in the original judgment. So what can he do? Because he's not getting that original visitation or parenting time since the alcoholism.
Here's the thing. So as long as the judgment grants him whatever specific parenting time or visitation that he has, that's what he's entitled to. The way that you enforce a judgment, so this would be what they call post-decree. Pre-decree is before you get your judgment for dissolution, and then post-decree is after that. So this would be post-decree afterward. Yeah. And so what would happen in order to force a judgment or order of the court, you would file what they call a petition for rule to show cause for indirect civil contempt. And basically what you're saying is, hey, look, on this date, a judgment was entered. This is what the judgment provided, and this is what the other party willfully and wantonly refused to comply with.
Because it's not a police matter. He can't call the local police.
No, although they do have visitation interference. That's what the name of the, and it's funny, you think it should be called, I guess, parenting time interference, right? They may have caught up by now. But I have had a few cases, and I would tell you in DuPage, they're really serious about it, and they will prosecute it. And so basically, you could be in a situation where you're in both places, and I had that. They thought it was funny because I brought in a court reporter into the criminal court because we also had very almost the same thing in the domestic relations court, and so generally you don't have a court reporter in the traffic court and the criminal in that case, because again it's like a petty offense, and so you can, and some places will give the other side a ticket, and but generally the way we deal with them is file a petition for rule. And so now understand that's only if it's without justification. So if, for example, he came to pick up the kids on his weekend and he was intoxicated and she refused to give it to you, and so she should refuse to give him, hey, you shouldn't let your kids go in a car with somebody who smells of alcohol or who's intoxicated or impaired or anything. So even though she denied him that parenting time, hey, that's the reason. And so, depending, again, it's the judge that's going to make that finding,
sure,
that whether or not, hey, it was willful or not. But now it sounds like since he's back on the track here on,
Yes.
AA, he's doing his what he's supposed to do. He's not drinking anymore. Realistically, I mean, he can come in on a petition for rule.
Well, the ex obviously doesn't trust that and is worried about
Well,
relapse.
but then she has options too. She can go in on a motion to revise or to modify his parenting time. Okay.
Maybe make it supervised where someone has to be
She
with
can,
him.
she can try that. There's a lot of different things she could do. And again, and now you're opening up a bigger can of worms and all the things we talked about in terms of guardian ad litem and mediation and everything else. Because very often judgments are written so that before you can come into court, the parties have to go to mediation to try to resolve it.
I mentioned that child is 10. Is it possible that the judge would want to have an in-camera meeting with that child and see what was the, not the relationship, but what was the circumstance as dad was visiting?
A lot of judges,
conduct?
right? A lot of judges don't want to do that, and because look, it's traumatic for the child. And I'll tell you also, when they do an in-camera interview, a few things happen. First, both attorneys and the guardian ad litem, if there's a guardian ad litem, but in this case, not right.
No.
Both attorneys are are allowed to be present, and a court reporter. Now, imagine that for a kid, that's going to be traumatic, and that's why the appointment of a guardian ad litem, because the guardian ad litem could talk to the child, and that comes in, and again, that's the court's right hand, that's the court's witness, and to advise the court on what's going on and how and so that's the way around it, so the judge doesn't have to do that.
Is there a way they can kind of blend this so that it starts out with supervision and then accelerates to non-supervised pending good outcomes?
Well, they could, but in this particular case, you told me he's got every other weekend and she's not giving it to him. She's going to have a problem.
Right. Okay. All right, very good. Let's move on to a Chicago case. This is about Laura, who writes in. Laura is seeing dollar signs. She's married to a Chicago police officer who is nearing retirement. He worked on homicide cases for about 10 years, fought against the gangs and violence during the last 3 years. However, he has not faced an adversary quite like his wife. She wants blood, Jesse, because he has a girlfriend, a very young girlfriend who's supposedly 28 years old. So her question is, my spouse has a huge pension with the city. I've been with him for 29 years, married for the last 6. What am I looking at? And that's key there. She's been with him 29, but only married for 6. She wants to know what she's looking at in terms of dollars. She wants to get her fair share out of this guy, especially now that he's dating someone much younger.
Well, I tell you what, she's entitled to the marital portion of the pension. And so since, even though they were together all this time, doesn't matter, she's only been married for 6 years. And then so she's only going to be entitled to that portion of the pension.
Okay. What about if they acquired some property while they were together?
Oh, if you're talking about other stuff, right? I mean, that's different. But if we're just talking about the pension, that's how you're looking at it, because that's what it sounds she's looking at. I mean,
it is.
In it, unfortunately, we're in Illinois. It's not community property like they have perhaps in California or some other states, but it's she's only entitled to that portion. And
during the time that they were actually
during the
married.
time they're actually married. In terms of
But
the
they're
other
still
stuff,
married. So let's say the litigation lasts for a year to 3 years.
Oh,
is she
no.
still entitled to that portion while it's accruing?
It's going to be, and the argument is, I believe, in the law, in terms of the date of the filing. Okay, actually, generally, it'll go through to the end of the
Date of dissolution, no?
date of well, when the judgment is entered. Okay, but you know,
That could be a year, 2, 3
it
down
could
the
be,
road.
but there's a good argument to say, hey, listen, this is when this was filed, and you know, the other person has strung it out, and you know, so there's things to argue about.
Okay, but in general,
Yep.
it's during the marriage.
That's correct.
And nothing beforehand.
That's right.
Okay. Let's look at Camilla in Riverdale.
Actually, let's step back. Let's step back for a second. So, if we're talking about maintenance, okay, maintenance. So let's say, because they have different things in the statute in terms of what you get and you know how long you've been married. So let's just say, in a week we'll be married 20 years, but I file now. Okay, so guess what? It's not 20 years because it goes. That will go by the date of filing in terms of you know what you get in terms of maintenance, how the statute is.
So that's the effective
so that's
date
a little
is the
different,
filing date.
right? Yep.
Okay, back to Camilla here in Riverdale. Camilla knows what she wants. She's not sure of how to get it. She's in a 28-year marriage, 4 grown children, a house, and a summer home in Michigan, 3 cars, and a house full of artwork. The parties have drifted apart emotionally. She wants 50% of the marital estate. And she wants to know, how can she be sure that she's not going to get screwed out of it? Her words, not mine.
Okay, well, Dave, I mean, there's only 2 things for sure we can count on in this life, and we can guarantee, and that is death and taxes. Other than that, you can't be sure of anything, okay? So it sounds like it's been a long enough marriage. It sounds like it probably would be divided 50-50.
Is there any chance she wouldn't get at least 50% of the marital estate under these circumstances and fact patterns?
And there's some things that we don't know, and there is a possibility. So
Yeah, we don't know the income of the parties.
well, we
now.
don't know the income of the parties, and we also, this is what we don't know. So let's say, so generally, everything acquired during the course of the marriage is marital property. And same with debt. And I say generally, there are exceptions.
Right, inheritance is separate if it's
right,
kept separate.
exactly right. So you mentioned that, so that's a good thing that you mentioned that. So let's just say that she has an inheritance from Uncle Harry of, you know, $10 million. And that's her money. She hasn't commingled it, she hasn't put it together, and hasn't put her husband's name on it. Well, the court gets to look at the party's non-marital property, because it's all about equity, it's all about dividing the pie. But the court can take into consideration that person's non-marital property. So let's just say the marital estate, I'm just picking a number, it sounds like it's worth more, but I'm just picking a number out of there. Let's say it's $100,000, okay? And she's got $10 million, and that's all he has, he doesn't have anything else. You know, she might not get 50% of that. And there might be some other reasons
What if the estate's
that
$2
might
million?
happen. Huh?
What if the estate's $2 million based on
Well, I mean,
what we might have here?
It could be. I mean, and again, it might not be. It just depends on those specific facts. Also, we don't know, again, about how much they make or anything else, how much she makes as opposed to how much he makes. You know, I mean, there might be, hey, she might have to pay maintenance. It just depends. Again, all these things are really fact specific that you really can't, you know, address completely when we get
Yeah,
the
now you mentioned
emails and
maintenance.
stuff.
Get into that a little bit. Tell me about maintenance, the tax ramifications, if any, the length of the time in general.
Well, I'll tell you, generally the statute talks about people who've been married, you know, 0 to 5 years, 5 to 10, and it goes on for that. And they have a multiplier. So you multiply how long you've been married by the multiplier in the statute, depending upon, you know, how long you've been married. And then...
and again, the filing date is what controls
the
on
filing
that? So
date.
if you
In terms of
file
the
short of
length,
5
right?
years.
Even exactly, if you've, you know, if your anniversary is tomorrow and you file today, although it's a little close, but
I think that's the
still.
California method that we adopted.
Well, that's what they're using, and the reason is so that, hey, it doesn't get strung out. Listen here, I would only had to pay this much for this long, for this duration, but you know, it's gone on for 2 years, and so now by virtue of the litigation, now you're going to get permanent maintenance. So that's kind of what that looks at, and then they take the gross income of the parties and they subtract the payee's amount. And anyway, so the bottom line is that it used to be that the payor, the person who pays the maintenance, could deduct it from his or her income, but it was includable in the income of the person who received it. Now, since they changed the law, that's not the case. So it's not includable, or it's not deductible by the person who's paying it, and it's not includable in the income of the person who's receiving it. 6 of one, half a dozen of the other. Under the old law, the person could get more maintenance because he got or she got a bigger break from the deduction of that money from their adjusted gross.
Right.
But now, and so basically, so who makes out? The government.
Right, because the recipient is usually in a lower tax bracket.
Right, right. And so now, again, the government makes out because all that money that would have probably have gone to the payment of it is not so. But again, it's not includable, and that's not a bad thing. So depending upon the amount of maintenance you're getting, you don't have to. And child support isn't included in your income.
Yeah, hasn't it simplified the financial equation, and that there's no tax consequences to be considered in that regard?
It has to an extent, sure. Yeah.
Okay.
Yeah.
We just have a couple minutes left, Jesse. A couple other topics that
sure.
you might want to talk about that we haven't gotten into, that we don't have a specific question for. But I wanted to talk to you about the grounds, because people used to have elaborate grounds in Illinois, and now we're kind of limited. So
Right.
Can you talk to that?
Oh, sure. We used to have mental and physical cruelty. We used to have habitual drunkenness, adultery, and of course irreconcilable differences, which was the no-fault ground. You had to live separate and apart for a continuous period of time in excess
Of 2 years.
Of 2 years. But all of that, except for 6 months, could be waived, and and easy to prove. And so basically, the way they would allege it in their complaint would be, irreconcilable differences, and then in the alternative, it would be mental and physical cruelty, which is really easy to prove. And again, you wouldn't need to wait that time. Living separate and apart doesn't necessarily living separate and apart. Okay, a lot of times people have moved to the attic or to the basement, or even sometimes they're still sleeping in the same bed, but they're no longer intimate. They're more like roommates. Okay, and so that's kind of what they're looking at, anticipating. Now it's just no fault, irreconcilable differences. That's the only ground, and you only have to live separate and apart for a continuous period of 6 months.
Do they have to wait 6 months to file? Do they have to be separated for 6 months to file, or can they file previously and then
You can file and wait.
make the 6 months?
You can make the 6 months.
dissolution.
It's right. It's anticipated because by the time you file it and everything that's going on, and it just depends on the circumstances.
Would a court really enforce that if it was less than 6 months? Would they?
Well, but
would they
that's
kick it out?
That's what you're testifying to under oath, and that's what the rules say, and that's what the law says.
If they both want the divorce, who's going to complain
Well, if
about
somebody tells me this is when they separated, that's what they're telling me, and I'm not asking. Look, I trust that my clients are telling the truth. So.
it? Okay. How about court costs? Let's talk about that. What does it take to file a divorce and get it done just without attorneys? Just if they did it on their own, which I don't recommend.
Well, so it depends upon what county you're in. It's going to cost about
DuPage.
Okay, so I believe in DuPage here. Ooh, let's say just
Roughly. Not going to hold you to it. Court costs change every year, just about.
I think you're going to be paying between $300 to $400 if you do it all together. So if you have an agreement and you file the petition for dissolution and the appearance together, that's going to be a big chunk. Everything's got to be filed electronically, although the law does provide for exclusions. Okay, so you could do it the old-fashioned way, and the clerk will stamp your paperwork.
Still no court reporters required in DuPage?
Well,
for prove-ups? They record them, right?
Well, they do because everything is electronically recorded.
So no fee?
Right, like in Cook County.
Cook and Lake.
Right, you have the court reporter, and you have to file the judgment. They used to back, they used to in some situations, especially when there's not kids, no children, they would waive the filing of the transcript. But they want to, the judges, the courts, they want to take care of their court reporters. So
You got it.
yeah.
All right, Jesse. Thank
All right,
you so
Dave.
much. Great information.
You bet.
We'll see you next time on Legal Action. Take care.